Thank you for joining us with the Dealing with Divorce podcast. Today's guest is Judge Warren Davis. We're here to educate the Gwinnett public on how to deal with divorce before, during, and after. Judge Davis was a big mentor of mine in law school, and I did an internship with him, and he's always been a great educational resource for me.
Well, you did an excellent job. You were a quick learner.
Well, thank you, sir. So, before you were a judge, what did you do?
Well, I came up through the Gwinnett County Police Department. That's actually where I got my start here in Gwinnett County, which was decades ago. I ran my starting salary, and I think it was about $4.40 an hour when I started with the police department, and I thought I had a great job. I then went in, the police department at the time helped me go to law school, and I agreed to stay after I completed law school for a while, and they put me in a vice narcotics unit at the time, so I wrote a lot of search warrants and wiretaps and things of that nature. And then I went out in private practice. I did a fair amount. I'd say my private practice was probably 50% family law.
Okay.
And then I actually started with the magistrate court in 1984.
That was the year I was born.
I just got my 40-year pin with Gwinnett County. So.
Wow. And so how did you get into law enforcement? What made you want to go that route?
Oh, reading too many Joseph Wambaugh books. But it sounded interesting, and it was, a fascinating career. I'm certainly glad I did it. I mean, Lord knows the streets have changed, not for the better, sadly, over the years, but it was an interesting line of work.
And what did you major in college?
I was actually interested in science, so I always thought I would ultimately do something more forensically involved in the law. But turned out as it turned out, and I'm certainly glad it did.
How did that interest in science help you as a judge?
Well, clearly helps you on things like the Daubert motions and things of that nature, but a lot of our cases have a science spin on them. Not so much the domestic cases, because the science there tends to be more of a softer science, dealing with psychology and sociology and family dynamics versus a hard science like chemistry. I do remember when I became qualified as an intoximeter operator, I corrected and they could rib me forever on this, because I corrected the number of carbon atoms that they had up on their board as to how the machine worked. No, that's not a balanced equation. They did not let me lift that down. So, anyway.
Oh boy! And so, in your life, what are the most important relationships that you've found most meaningful?
For me, despite being in the public eye, I'm a true introvert. I can do a speech in front of 500 people and be very energized, but afterwards I decompress. I have just, primarily family.
Mm-hmm.
And
what family do you have?
Oh gosh. Well, I've got 7 children, including stepchildren, that I've raised for 30-some years. I've got, I think last count is 9 grandchildren. And over the years, we had 14 exchange students. So
wow.
Yeah, so that was a different spin. So we had children live with us from all different parts of the world.
Wow, so you've spread your wisdom far and wide.
It depends who you ask.
So, are there differences in the needs of children at different ages?
Oh, sure. And it's part of what we see in custody, modification of custody or parenting time cases, is children evolve, their needs become different, their relationships become different, their parent-child dynamics become different. There's a whole host of reasons there. So, I mean, it's not a straight line either. Oftentimes it's a winding road.
Is there any particular advice that you've given your children when they've had children? Young children, early on in their childhood. What kind of advice would you give a parent?
You know how parent-child advice can go sometimes. I think the best advice is by example, rather than coming out and saying, because they've got their own road, their own mind, and but developing the closeness, trying to do things that are fun, trying to do all the different aspects of what makes a family and its memory. I think if one thing is don't work all the time. That time goes by fast, and it's never coming back.
Are there any patterns that you've seen in raising so many children as far as the emotional needs of boys versus girls?
Well, I think I'm glad that moms are usually in charge of teenage girls between the ages of about 13 and 16. That's a tough age for moms. I mean, there's just something about, girls in middle school. It can be a real struggle. A good friend of mine was a middle school teacher and taught the 7th grade, and she said, Warren, every day there's a girl crying in my class. It's just not the same girl. And those are tough years. Identity and who's in, who's out, who's friends, how they find themselves. So yeah, I mean, whereas boys are more inclined to grow with a modeling. That's why a male figure is so important to young men, be it a coach, hopefully be it a family, father or a family member. But by the same token, with young males, it's one of the reasons why those who struggle and are left alone in some of our neighborhoods gravitate towards gangs, is because that dynamic of being part of something. And it's just part of what makes it complex.
Mm-hmm. Yeah. What kind of skills can a parent teach their children to help them be a good partner one day?
Well, you've got your early stages, with your bonding there, and then you've got up until the teenage age, where you're trying to teach them basic functioning, getting along. What's that classic book, Everything I Needed to Know I Learned in Kindergarten, or words to that effect. And then their teenage years, I mean, as they gravitate away from the nuclear family. I mean, 17-year-olds don't like to hang out with parents at the mall usually. They want to be with friends and peers, which is how they grow up. They bond more and more with peers and less with their nuclear family.
Mm-hmm. And what advantages are there to getting married before having kids?
Before getting kids?
Mm-hmm.
Well, stability of relationship, hopefully an opportunity to have at least put some of the initial financial struggles behind. Because in this day and time, Russell, it is so difficult and so costly, for infant care. Oftentimes, like for Gwinnett County, the basic cost of living is you got to make at least 48 to 50 grand a year to live in Gwinnett County, given the cost of housing and all the other issues that go with that. And this is why it's such a struggle for divorce for people with young children, particularly before pre-K age. Because, I see our weekly daycare of $275 to over $300 a week. And how in the world does a family pay that with after-tax dollars and still survive? And that's probably one of the sad aspects of when I get the divorces with parents, they come in the back door in their middle class and they leave the courtroom at the poverty level because there's only so much to divide.
I mean, I've told people in my office, looking at your financials, you might want to wait until this child's in school before getting a divorce, because I don't know how you're going to do this.
It's sage advice for those who can do it. As we know, there's people that their relationships are so bad, so poor, so toxic, that, another hour seems like eternity to them. But if there's any way they can solve it during that, to at least give themselves a chance of a reasonable economic lifestyle. It's also one of the reasons why you end up with so many relocations outside Metro Atlanta. They can't find housing, and then you see, oftentimes the custodial parent will move back near a family or move in with family. That may be in Metro Atlanta, and it might be in Montana.
Do you think there's a level of income or a certain age that someone should be before they really start thinking about having kids and after marriage?
Oh, no. I mean, I've known people that have been married 50, 60 years and got married at 18 and 17 or 16. So there's no magic fix. I mean, I think different generations tend to choose things differently. Either, this is the right age or the wrong age, but, there's always exceptions, always outliers. People are so complex that's why we don't have one size fits all. And the same goes for marriage.
At one point, you told me a story about the adolescent brain and the developing brain and how teenagers make decisions into early adulthood. Could you share some of that?
Yeah, actually, it derived from a National Geographic article, and I was doing a professionalism paper on decision making, and it was decision making concerning adolescence. And the anthropologist, the study of teenage brains it's actually perfectly designed for what it's intended to do. And I thought, that's one of the craziest things I've ever heard in my life. This person's obviously never raised teenagers. But then you go into what the study of it was. First of all, the brain is not hardwired. The decision making is not there. I mean, you would think, well, what is the purpose of that? That we're trying to make certain everybody survives and makes good decisions. Well, for a teenager, they don't know where their life's going to lead them. They don't know what the type of decisions are they're going to have to make, and so their brain is actually malleable. It's why a lot of times, they say, females tend to mature mentally a little earlier. There's a mixed audience as to whether men actually meet their mark at 25 or not. Depends who you ask on a given day. But that's part of it.
If you ask my wife, I'm not there yet.
Malleability, adaptability. The other thing is the teenage brain is risk-taking. Now you would think, oh gosh, that's a bad. Well, one of the biggest risks a teenager ever takes is usually at age 18 or 19, if they're not still sleeping on their parents' couch, is they do that risk-breaking of going out in the world on their own. And if the brain wasn't wired for risk-taking, they wouldn't do that. The other aspect is the social bonding. Teenagers very much into, those of us that have raised teenagers, there's a time when they will go travel with you, and then there's a time where they better have a best friend with them when they travel or go someplace with you. And if they haven't heard from another teenager for the last 45 seconds, a panic may be setting in. But that social drive is to go back to the time of, if you weren't part of the village, If you were ostracized, it literally was a death sentence. And so the teenage brain is wired to make those social connections of who they're going to work with, who they're going to be, what they're going to be a part of, where they're going to find a mate, raise a family, and things of that nature. So when you look at it from those aspects, the teenage brain is designed perfectly for what it is supposed to do.
Yeah, because it doesn't make a lot of logical sense to leave your family and everything that you know and go off
no.
and find some other
Roof
tribe.
over your head, meals made, food, shelter, things like that. But we're wired to do that.
Absolutely.
Wired to take those risks. And let's face it, that's oftentimes a parent's nightmares. Where's my child this time of night? And that's part of it as well.
Well, if someone's got married and they're having some marital issues, what kind of resources can they seek out, given that sometimes it's hard to talk to your friends and family about marital problems because they're going to judge long after the problem's been resolved? So what kind of resources could a married couple go to for help?
Well, going to a counselor that fits for them is always a good choice, but it has to be a fit. It's not the one size fits all. You've got a lot of variables in relationships. Unfortunately, you've got some things, from genetics and substance abuse issues, maybe on both sides. You have a clear group of personality disorders that, depending upon who you ask, can represent up to 15% of the population. And those things don't change. You don't change genes. You don't change. You might get a little modification on narcissism, a true narcissist, but a lot of your other personality disorders, it's been derived since childhood. It's a learned behavior, and it's either going to be a fit and it's going to be adaptable, or it's not.
Is there a certain age where those kind of get cemented in and the brain's not malleable, or is that able to change at any age?
Ironically, it's right about the age people get married, because again, it's some is genetic, and let's go through what those are so we know what to talk about. These are, you've got your narcissist, which is, in popular terms, it's everybody's ex-boyfriend, girlfriend,
Exactly.
ex-husband,
Yeah.
ex-wife. Well, okay. That's popular terms, but there is a small, finite group. They lack empathy. They are always the victim. Actually, let's do the personality disorders that we see in court. And I would recommend anybody that wants to study that further to go and look at the work of Dr. Bill Eddy, and that's spelled Eddy. They have an institute that has been training people around the world on high conflict people and litigation, primarily family matters, for decades, and it's highconflictinstitute.com. So you've got your narcissist, very self-absorbed. The difference between these personality types and high conflict is the personality types are chronic blamers. Now, for a lawyer, for coming into your office, they are the one that will bring in an accordion file, and it might even be color indexed, because they are really wired into blame. The other component
That's an interesting observation.
They want attack. That's what they want, which is why their attorney's fees are so through the roof. And they're blamers. In other words, it's always somebody else's fault. It is absolutely zero, any part of it them. So let's go through who they are. You've got your narcissist, and then you've got your next group are your antisocials. Your antisocials are really like, think of them in terms of a sociopath, psychopath. They're very much into a con. If they could make an honest living, it would bore them to death because there's no hustle involved to it. They're very much into manipulating others. A lot of game playing in that regard there. Your next group would be your borderlines. And when I say borderline, I don't want you to mix this up with the diagnosis of, those who hit the borderline as far as that. This is a personality disorder. It's not something for medication. And your borderlines they'll go from love you, hate you, love you, hate you. Kind of like, that's why you call it a borderline in that regard there. And it doesn't take much to get them going. They are driven very much by a fear of abandonment, which is what kind of drives that emotion as to whether you're for them or against them. They're the kind in a high conflict setting that are most likely to come in, bear a grudge against someone, get even. In other words, litigation is to vindicate them against this person that did them wrong, be it a spouse or else. Then you get your histrionics. Your histrionics are, a flair for drama. They are the kind with blue, pink hair. In other words, call attention to themselves. It's usually more female than male under this personality type, but they are very much into the drama of storytelling. If you asked them what happened yesterday, well, it might be they met so-and-so, that one time they saw so-and-so, and it was in New York, and I couldn't believe I saw this person. And in other words, the stories don't have a linear progression. They do lots of zigzags back and forth. In a high conflict case, a personality case, your histrionics will try to draw attention to themselves. Again, this can be various ways. They're oftentimes likely to be self-destructive because if they're not getting attention, they will do something to get attention. And you can't always predict what that's going to be. Your last of these types, the high conflict types that really drive family law litigation, are your paranoids. And that's the only part of a personality disorder that is actually on axis 1 as a mental health diagnosis.
Okay.
But it has a personality. And of course, they're suspicious about everything. From those attorneys that may be watching this, if you get any indicia that you're dealing with someone that may have this paranoia, in other words, they're big conspiracy thinkers, you have to approach the conversation assuming that you're going to be misunderstood.
Yeah.
Because they mistrust inherently everyone. So the way to one of the helpful ways to deal with them is to break it down as to what you just said, but then ask them what you said so that you can correct it.
Yeah.
And you have to very much with your paranoids keep your tone even when you're really frustrated. I have told you this 10 times and they didn't get it. It's part of their wiring. So I've put this in a legal setting, and now you can put it into a life setting. And they are a general part of the population, and they make a huge part of our very stressful family law cases. Because remember, it can not only be the participants, it can be the attorneys involved. I mean, this is a cross-section of the community. It's not one size, for everybody. They're all just participants, everybody else is normal. No, it's a mix.
Yeah.
But I mean, it's the insanity where I'll see People spend six figures on a modification of custody case for a child that's over 14. There's zero reason for that other than the personalities involved. So sadly, in family law cases, a lot of the issues are not legal issues. They're personality
Yeah.
issues,
And
and sometimes some other mental health, illness, and substance abuse issues as well. And so that's why, for those of you that wear the mantle of a family law attorney, it's not only the law, but it's the people, their thinking, their sociology, what makes them tick.
And from my experience, counseling's not going to work unless both sides are working towards it. And if you have a blamer, then they're probably not open to the idea of they have something to fix too.
Well, they end up creating a challenge, which is in part why I said, the counselor will play a big role in that, because the counselor has to have a really good grasp of, and it takes a few meetings. Like, for an instance, a narcissist is going to be really charming at first. I mean, so smooth, like you've met your new best friend.
So how do you see through that in just a
It
couple
takes a
hours
while.
at a hearing?
It's an imperfect science.
Yeah.
But you do kind of look for the blaming part. If there's no, like oftentimes in a custody case, I'll ask just to see what the tempo is. What does the other spouse, other parent do well? And what do you feel you could do better? Questions like that help me identify whether or not a narcissist oftentimes will tell me, when I ask about the child's needs, because that's really what a custody case is about, the best interests of the child. And a narcissist will typically respond, more time with me. I mean, that's what the child needs. But they truly see that, and they have a hard time, they have a really hard time with empathy for the other parent, even though that's the other parent of the child. Very little empathy, and that'll come through pretty stark.
So I've got a hypothetical for you. If a couple married after high school, went to college, grew apart, 6 months later they both want a divorce, no kids, no joint assets, both live in Gwinnett, just the most simple divorce I can think of. Is that something someone can do on their own?
Yes, and sadly, right now, and I'll say sadly, and I'll explain it in just a moment, is a substantial number of the people we get in family law cases are currently self-represented. And it's a problem not only in Georgia, it's a problem across the country. Clearly, no assets, nothing to divide, no joint MasterCard, no past due taxes from the years 2020 forward. No houses, no mortgages, no transfers, no closely held corporations. Those are easy cases. And tomorrow, Tuesday, this is actually my family law week. I'll probably have 50 to 60 of those on the calendar.
Wow. How many cases do you have?
Well, at any given time, Russell, I think my most recent number was 470 civil cases, and I'm right about the same number for criminal cases in the pipeline. A Superior Court judge in this county carries open cases between 800 and 1,200 cases at any given time. But I'm just tomorrow's my uncontested divorce case, which is a euphemism, because a few of them all show up and they're contested.
Yeah.
I do those in the afternoon. But no, But part of the driving force is, we're in a do-it-yourself mode now. We have people that, buy a kit, do your own divorce. And sometimes it's easy for those very simple ones. The problem becomes that they don't know what's simple and they don't know what's hard. They think if they've reached their own agreement on child support, that's what the law is, and of course that's not. In fact, I was using your formula that you sent me, that you created for the parenting time deviation before I came here today, because I had a joint physical custody and they wanted no child support, and one parent earned twice as much as the other. There's still child support. There's a parenting time deviation, but there's still some support. And so people don't understand that. They don't understand, well, I agreed to give her the house. Well, whose name is in? Mine. Well, whose name's the mortgage in? Mine. Well, it may not be as easy as they think. Or they've got clauses like, well, I'll give my spouse 18 months to refinance the house. Well, that's rather pointless if the spouse is a stay-at-home mom. You could have 2 years earning most of the time to qualify for a house. So there's a lot of subtleties that go into what we do that is that old adage, you don't know what you don't know. I mean, I'll have people come in to represent themselves. They've got property in 2 states, a timeshare in the Bahamas, to their best knowledge and recollection, a closely held corporation, and some other multiple issues. And they have no idea. Sometimes you've got substantial premarital assets or you've got inheritance, and they walk in. And, I can point them to resources, but I can't give them legal advice.
That's kind of what I was going to go into next, kind of the opposite side of the spectrum. If you had a 20-year marriage with one working spouse who owns a business and controls all the finances, and the other spouse is a stay-at-home parent with a 12-year-old child, and the child's flip-flopping on which parent they want to live with, and the stay-at-home parent files a divorce, just uses a form online and files a divorce, and 12 months later you schedule a bench trial and nothing else has been filed in the case.
Well, if they represent themselves, I fast track those.
Yeah, okay.
I have to fast track them. I mean, Russell, you're a practitioner. When's the last time you had a self-represented litigant, we call them SRLs or pro ses, actually give you verified answers to interrogatories? Was it
Never.
the summer of '79 or something?
Never.
No, they don't get discovery. And, you can do a whole bunch of motions to compel on that. It's not going to change that aspect. So you might as well just put those up, just try them. I'll get motions to strike pleadings. Well, there's no defaults in divorces. You can't strike somebody's pleadings on that. They don't even have to have pleadings other than the plaintiff. Defendant can always show up and just ask for a trial, ask for a jury trial. So when I get in the complex cases, I tell them it is a complex case. I encourage them to get counsel, each of them. Now, the Georgia Constitution has a unique clause that in Georgia you have an absolute right to represent yourself. And some people, you also have an absolute right to take out your left or right kidney if you want. Neither of them are particularly good ideas, but you got the right to do it. And so you just try to get them going in the right direction, because one of the things, family law cases, particularly as you described, I'm making a decision concerning a child. And I make those decisions. That's why judges sign off on parenting plans, and I'm not a rubber stamp. That's why judges determine child support, irrespective of what somebody sends in to me. You know, that's what the law says I have to do as a gatekeeper. So you want to make the right decision, but you can only make the right decision if you get the right facts. When I say right facts, those things that are required under the law. In other words, if this is an alimony case, you know, what is the checklist for those issues? If it's equitable division, what's the checklist? If they don't even know to tell me that, how can I do it?
And so what
Or
if this,
be prepared.
what
I
if-
can ask them questions, which I'll do.
so what if this non-working spouse comes in on the trial date and asks you to give them a lawyer? Can you just give them a lawyer?
Can't do that on a civil case.
Why not?
Who am I going to give them?
But don't you have a right to a lawyer? Everyone knows that, right?
You have a right to retain counsel. You have a right to represent yourself, but this is a civil case.
So only in criminal cases you have a right to a lawyer.
Yes. In other words, can't say right to a lawyer. You have a right to a lawyer in all cases, but sometimes it's
Okay.
the client's responsibility and sometimes it's the government's responsibility. You have a small segment that will qualify for help through Atlanta Legal Aid or what's called the Gwinnett Family Law Clinic in our county. But you know, it's a small group that they represent, and they turn away way more than those who apply for services.
So what happens if that non-working spouse says that they don't have access to any money to get a lawyer?
And I take it the other side, the controlling spouse does.
Yes.
Well, you know, bear in mind, I got to have a motion. I
That's
could
what
get
I
a
was thinking.
1962 motion, but I can't request or work on a motion to take money from the other side. I cannot do that.
Absolutely.
That's where the transition goes, and you've hit on something that actually I'm working on with the Supreme Court at this time on modifying some laws in Georgia concerning that. But what they encourage you to do is to be more informational. Now, think of how that goes. The lawyer wants me to strictly hold them to the law, like answer interrogatories,
Yeah.
has to be verified, request for production of documents responded in 30 days. You know, hold their feet to the fire on everything, not ask them any questions. Because the worst day in the courthouse for a lawyer is to get beat by somebody who wasn't in the court. I mean, I get that, but that's not really my job either.
You have to find the facts.
You know, it's a hard day for practitioners. The science recommends that, you know, for two self-represented litigants, it's more easy because, you know, I've got an even playing field. I can tell them this is the law, this is what it is, and oftentimes I'll use my jury charges. In other words, what would I charge a layperson jury on this aspect of the law? And I use that to talk to my self-represented litigants. When I've got one lawyer and one that, you know, I've got one side that requires that or would like me to be very strict, and the other side that's absolutely clueless to what this is even about, other than I want a divorce and I want what's fair. Well, tell me, what evidence do you have? And they look at you with a blind look. Well, for that group there, you're supposed to do it more informational, more informal, more ask questions. So you can deal with information. You cannot cross the line to legal advice. So, you know, our Gwinnett Family Law Clinic's an excellent resource for those, but I get a group of cases where it's very appropriate, represent themselves. Maybe they haven't even seen their other spouse in the last 10 years. So it's a divorce by publication. There's nothing to it. And then I get an equal number that, my word, folks, you should not This is probably the most important legal proceeding you're ever going to go through in your entire life, and you have zero idea what you're doing. And I can't represent them.
Yep. And I have a lot of compassion for the people who come in my office in that situation where they don't have the money to retain a counsel up front. And it really speaks to me as far as the importance of maintaining a social security net around you of people that will help you in your time of need, and not just having the one person be your spouse, because if something happens between y'all, you got to have somebody else to fall back on.
It's pretty hard to pay the rent that's required, and even with just one child at $15 to $25 an hour, it's just plain hard.
So if somebody without a lawyer comes and just asks you, can you just subpoena these records? They're not giving me the records. Can you do anything?
Depends on what's before me.
Okay. Yeah.
I can point to resources, and I generally, you consult an attorney. You can go to the Gwinnett Family Law Clinic. They've got this, but
yeah, they've got a lot of forms. Are their forms good?
For the most part, yeah.
Okay.
I mean, they've had some very excellent family law practitioners within legal aid. They're true specialists, as well as members of the bar that kind of worked and collaborated and put them together for the population that needs to be served. Now, of course, on my custody cases, I can send my custody cases to juvenile court. I really don't send a lot there. But if I find one that is, reasonably complex, well, sending it to juvenile court allows me to get the child paid guardian ad litem. I can get social services involved because they have, juvenile court has more of a net to help there. I can actually get home inspections, things that I can't do as a superior court judge is quite normal for juvenile court. So sometimes I'll send a case to juvenile court just because of the needs of the children are so profound. And, maybe I've got two parents, one just got out of work release and the other one's recovering addict, something else. So, I mean, these are not all easy cases.
Earlier you mentioned the best interest of the child. I'm sure that parents always think that they know what's best for the child. How does the law guide you on determining what's best?
Well, on my contested custody cases, I'm a firm believer of going to 1993.
And 1993, for the viewers, that is the Georgia law is Official Code of Georgia Annotated. That's OCGA. So if you go on Google, search OCGA 1993,
yes.
Then you'll be able to see those A through Q standards and then some more after that.
Yeah, and it's a very good outline. I actually rearrange the code section. I don't go A, B, C, D, because there's certain aspects of it that are more critical than others. And so I try to deal with them. Like let's say that a parent is seeking, or they're seeking joint physical custody, and they have young children, school-age children. Well, one parent works overnight shift. Well, how are you going to have the child cared for then? Well, recently I was told my landlord's wife said she might be able to help. Well, okay, that's not exactly the answer I was hoping for. But oftentimes you'll have, one parent lives in Sugar Hill, children go to school in Sugar Hill, and the other parent lives in Loganville. How in the world, just that distance, where do you live? Where's your neighborhood? Will give you guidance as to, or the parent that works, I get done by 2 o'clock in the afternoon. Well, that's great. What time do you start work? 5:30. Well, how do you get daycare? for two children at 5:30 in the morning, and you've got to be up by probably 4 or so. You know,
Yeah.
what are the
It's like they,
children up?
they thought about the emotion, but not the logistics and
Yeah,
how
no,
it's going to
and
work.
so it gives me guidance on logistics, you know, who else is in the home, you know, if I've got somebody else in the home that's, you know, just got out of prison. And it's amazing how often people in that bounce back relationship oftentimes make a poor choice as to who they've brought into their home. I mean, it's not the one-to-one correlation. Sometimes a person they brought into their home's extraordinary and a true benefit. So you have to live, but it's got some good issues concerning neighborhood, school, continuity. It truly is the best needs of the child. I mean, I taught a class last week at the Superior Court judges, and I said one of the things I have in a contested custody case is an ironclad rule. The parents or lawyer have to mention a child's name once every 45 minutes because, and the reason is so many of these custody cases, particularly with your personality disorders, are just blame. In other words, blaming the other parent. What a lousy spouse they are. Well, I don't award little Becky and little Jimmy to the least bad spouse. I award little Becky and little Jimmy to the parent that takes care of the child.
Because spouse and parent are very different roles.
And you can have somebody that was maybe not the ideal spouse and said and did some things that you, but is literally there for the children. So it's a needs of the child. And you hit on it right at the very beginning. The needs of a child are fluid, different times of the child's life. So who takes the best care of meeting that child's needs given the time that they're in front of me? And it's not a mudslinging contest. It's a child's need contest. And you'd be surprised how many parents do. You might think I'm being facetious, but it can go that long in testimony and exhibits and want me to look at this Facebook page or videos from their phone that have zero to do with the child. Zero. And that's sad.
That is. That's sad. So I'm going to touch on real quick, educational aside, on due process. The basics of due process is that you have to have notice that you've been sued and an opportunity to be heard at court. So with due process and a divorce, how does that work if your spouse moves off somewhere and you don't know where they are? Can you still get a divorce?
Well, you can, but there's some limitations on it. Actually, this is one of the forms that I would say the Gwinnett Family Law Clinic does a good job on, which is that affidavit of I've looked for them. I've gone through all these resources. I mean, I can count on my attorneys to give me a really good affidavit. So they can do service by publication. The hard one is when the parents come in and they're seeking contempts. You can't put that in the newspaper. You got to get personal service.
Because you go to jail for contempt.
You can, and you hit on that with the due process aspect. So the due process is in part driven by what you're asking for. If I get those cases that qualify for service by publication, and I get those even with minor children, I can grant the divorce because that service by publication is valid for a divorce if they've done the affidavit, published in the newspaper, and pay that fee. I can also do custody of the child because the child generally is in this jurisdiction with the parent that filed. I can't award child support because I don't have the appropriate service on on the parent who is not able to be found. Sadly, though, this is again one of the reasons why I like having lawyers is I don't have these games. I'll end up with people representing themselves that are not completely honest about not being able to find their spouse, even though they've dotted all the I's, crossed the T's. And then maybe a year or maybe it's even been a few months later. Wait a minute. What do you mean saying didn't know where I was? We went to dinner. And so those are problematic. You'll have people that game the system and don't have to abide by a code of ethics. And that's frustrating. And it's also sometimes gives rise to some other issues, which, contempt, you got false swearing. I've had some of those that are so blatant, I've turned them over to the sheriff's department, court security. This is what came in, you all investigated, and they make criminal charges on those. So, but service is critical. I mean, if I don't have valid service, I don't have jurisdiction. And I have a whole calendar. It's called the no service calendar, where I'll go through another 40 or 50 cases. You don't have service, give you X amount of time. Again, I can point them towards resources. But service can be hard with somebody that doesn't want to get served and wants to hide out.
Absolutely. We have the freedom to travel and not be found.
That's true.
So on a parenting plan, the two most common kind of schedules I see are like alternating weekends and holidays, or like 7 days on, 7 days off. What are your thoughts about the advantages and disadvantages to each of those?
Well, it kind of fits the parenting dynamics. If you've got two reasonably good parents who are willing to live in close proximity to one, and a lot of people don't get divorced so they can live, 2 blocks from their former spouse. Doesn't have to be that close, but that's not what they're intending to do. So if you can solve that, and ideally for a joint physical, where it's pretty close, either is 50-50 or very, very close to it, being in the same school district if they attend public school. That way you've got get on the bus at a different location, get off a bus, after you've jumped through the school loops and that. Being able to get resources back and forth. I mean, joint physical parenting works for that small group, and sadly it is a small group that actually can do it. Then you've got your 2-2-3 rotation. So there's different ways of doing it. For a lot of parents, those who either can't get along or they live a substantial distance apart, so they can't get children to and from school. They don't have the safety net to deal with, the child's sick for the last 3 days and I got to go to work. They have no resources to deal with that. Well, then you got to look for the best interest of the child, where 50-50 is not in the cards. It's not what's dealt. Or one parent is so far off on the pendulum of child care and the other parent maybe in the other. I mean, there has to be a fit. And sometimes there is. When there is a fit and they're good parents and they can work together, it's really the best outcome for the child. It's just sadly so rare. People get divorced don't always work well together.
Absolutely.
And, we've always had this, but with our parenting time deviation coming up that starts January 1, you're probably going to see more of a push because it's such a substantial offset. We've always had people that would claim joint physical custody really for child support purposes, nothing else. And then we get another group that talking joint physical custody because they really both should and want to be part of the child's life.
Talking about the child support, I understand you're on the Child Support Commission Advisory Board?
I like gadgets. I'm on the calculator.
The calculator, okay.
So
Subcommittee.
it's been quite a saga, but it keeps me on the cutting edge of what's going on, and I've been able to have some input on that over the years, and help it be a more user friendly site, because a lot of people don't. This is what people will tell me. Well, we've agreed on child support. Well, that's about the only thing that I can tell you for a certainty I can't approve. So I got her on the numbers. And that goes back to the 2010 or 2011 case on that. Mere agreement of the parties is not sufficient for a child support deviation, because parents have their own self-interest, and child support's supposed to be for the child. So that's why they make judges calculate it.
So you mentioned there's going to be a change in the parenting time deviation, being a parenting time adjustment now. So
Yes.
how is that going to be measured? How are they going to measure parenting time?
The model that we chose to go for primarily embraces the Minnesota model. And what it does is you have to do it a period of 2 years. You can't just do 1 year, because you get holidays that may, like, say spring, and it's determined by overnights. And let's say you do a spring break, alternate years, back and forth. Well, 1 year's one parent's one. So it takes 2 years to embrace those alternate year provisions for holidays and breaks, and which part of winter break may be longer. And so it calculates, you plug in what your times are over this 2-year thing, and it will tell you the amount of parenting time. And as you know, you were one of the first to work on was there's a formula now within the child support guideline statute that actually walks you through what to do with the days each parent has. So your ratio of days or number of days you get from putting in that 2-year calculator, and then you plug those numbers into the other formula. And that's what we're working on to incorporate as well.
And so once the new child support law goes into effect January 1st, does that mean that everyone who didn't have a parenting time deviation could be coming back to court for a modification of child support?
Yeah, that's what the intent of the law is.
Okay.
And of course, there's always guesswork. Some parents have lots of parenting time and hardly ever exercise any of it. And other parents, maybe their parenting plan called for alternate weekends, but the parents have worked something out between themselves, and they share more than that. A parenting plan is really what your base rights are if we disagree. The parents can, have a right to reach their own agreement, but they don't have a right to bring their own agreement in and say, put them in jail because they didn't follow it.
Yeah.
But they do with the court-ordered one. Given the number of cases I have over a given year, my parenting time cases were true abuses, thank goodness, are really a relatively small portion.
That's good.
Yeah, that is good.
So what are your thoughts about a meretricious relationship clause in a parenting plan? Neither parent shall cohabit with another parent of or another person of the opposite sex while exercising parenting
I say
time.
go read the Beal versus Beal decision, Beall. That used to be a popular clause amongst parents and divorce attorneys who had never been divorced. Those that had been divorced said, there's no way in the world we're going, you get a clause that you must date someone for 9 months before you introduce them to a child, and then it'll be done in the presence of the other parent. Oh, that is going to go really poorly. But the Beal decision said, well, that's fine, but when it comes to holding someone in contempt, you have to show that this third party has an adverse effect on the child. And quite frankly, that very seldom happens. I get people that will enter that clause initially thinking it's a good idea because, it may have a religious aspect to them. It may be just they were encouraged to do that. Some of them are in good faith, and some of them are really just about control. Controlling the other spouse after divorce. Our job is not to get involved in the control games, but look out for the best interests of the child. So again, without an adverse effect, those clauses, as of, I think it was a 23 or a 24 decision, take an entirely different spin now.
So would you, given that case, if that was in agreed upon parenting plan, would you be okay with it because you knew it wasn't enforceable, or would you
Well, I want
push
the
back on
parents
it?
to know that it's not enforceable. I mean, oftentimes I'll say that I can't. In other words, I'll approve their parenting plan, but I won't include this clause in any sanctions for contempt. And I just put that in the final judgment decree because it's contrary to law. I oftentimes, even before Beal, would encourage people to think long and hard about that. It's one of those things that sounds good, but clearly there's an appropriate line to be drawn, and you clearly don't want a whole bunch of new partners coming in every weekend or things like that. No, there's a line, but some of the clauses were really onerous, and it's pretty hard to get on with a parent's life with some of them. In fact, rather than getting on with their life, they get on with a new fight and new attorney's fees and new court time, and that can be just as counterproductive and destructive.
So much of what happens in a marriage, happens in a home with only two people and no other witnesses. So if the only witness is somebody that comes into court and they've got a video on their phone of something, is the court equipped to look at that video and take it as evidence?
Well, you can't enter your phone as evidence. So which I get videos. Look at this. Well, mark this phone as Plaintiff's Exhibit 7. It's going to go with the court. No, that's not what they mean. Of course, I get paycheck stubs on phone.
What would make your job easier if they did to prepare to come to court with that kind of stuff?
Well, Russell, there's different types. There's types of bona fide. I mean, bear in mind, it's all credibility.
Okay.
There are clearly fights, arguments. I had one concerning two parents that got in a fight at a child's, I think it was a soccer game.
Oh.
I mean, both of them. I mean, the poor child's devastated, humiliated. This is a young teen girl, so of course, really embarrassed about that. Hypersensitive to that. So that's one side. You also get, as a trial judge, you get the stage video where there's a whole bunch of things that went on beforehand that got things going, but then the one spouse that's going to record it knows going to record it and becomes totally calm. Talks in a low tone of voice, and the other parent's bouncing off the wall after they hit the record button, and that's pretty patent. The manufactured fight is, sadly a production we get, not all of them. I expect that parents or parties who are coming into court to get a divorce have argued, said terrible things to one another.
It's a given. Yeah.
Yeah. So I mean, it's generally it's the sort of thing you listen to in appropriate cases, do some reflective listening so they feel heard. But it also goes back to what we started talking about at the very beginning, that is the sort of evidence that your high conflict personalities would
come to
bring
you
in.
with, yeah.
Because the blame, the I am the victim. And so it's like everything else. We don't, at a true trial level, we get some things that are stark, black and white, a bar. But we get lots of shades of gray because that's just how people are.
Mm-hmm. Yep. One of the first questions you always ask at trial is, would you like takedown? Could you explain what takedown is?
Yes, my court reporter will appreciate my talking about takedown. Takedown in a civil case is where I ask whether or not they want to have the court reporter take down the testimony or the argument. And the purpose of that is so they have a record should they want to file an appeal later. And they got a right to file an appeal. To prevail on an appeal, if you don't have a transcript, your chances of prevailing are pretty close to zero. Not absolute, but a lot of things are, what the ruling was, what the record was, what the objections were, various rulings on that, and that's really what they're appealing. So it's vital. There's a statutory cost in a civil case. Currently, it's about $44 an hour. And if both sides share in it, then they have a right to order the transcript. Takedown is not a transcript, and that's one of the things that the self-represented litigants don't understand. Well, I paid to have it taken down. I want my transcript. No. That's an entirely different cost and goes by the page.
So the takedown is kind of just a very rough draft that later on when they want to make the transcript, they have something that they can do that with.
And why it's important that I ask people if they want to share, because if one side, let's say that you agreed to have it taken down and the other attorney on the other side said, no, we don't want it. The other attorney can't ever order that transcript because that's yours. You paid for it. You paid for takedown. So it's a way of assuring people have another avenue to have their case reviewed should they wish to do it. And it's important, which is why I have to tell them the pros and cons.
So I feel like takedown or court reporting and all that, it's kind of dates back to times before we had audio recordings. Do you think that the courts are ever going to get to a point where we just hit the record button and record it as opposed to having a court reporter?
I don't, and I hope we don't get to that stage.
What would be a problem with that?
I mean, right now, the Georgia Supreme Court has changed the rules a little bit concerning digital recording. The court reporter does much more than just take down the testimony. A lot of your things in an audio recording, those states that have gone to that, some of those states that have gone to it have come back to court reporters because it's just not accurate. You will never get a complete recording of what somebody said at the table. Between a set of ears and the court reporter takes down a recording as well, going back over that, you'll usually get it right. But, remember the court reporter deals with the transcript. You've got to have a transcript for an appellate court to review it. They're not going to sit and listen to a 4-day trial. Can't do it. So there has to be a transcript. You have to have a way of getting it to that. You've also got that in a trial, which is very vital, which is the evidence that's admitted. Most clearly with our self-represented litigants, they don't know how to do exhibits. They don't know how to lay foundation. They don't know how to even keep the record after the trial.
Because the court reporter kind of listens to what stuff was actually admitted by the judge, whereas
So imagine that you didn't have a court reporter. Well, who's going to keep the exhibits?
Who's going to keep the exhibits? That's a good point.
Which one's going to get lost before it goes to the higher court? I mean, you've got safety backups. Now, with the digital recording, rather than using stenograph or mask, they high quality can do that, but it's monitoring. It's if the case is important enough to be taken down, it's important enough to be taken down right, and to have a record that parties can use for their right of appeal.
All right. And so at the end of the hearing, sometimes you make a ruling from the bench, and sometimes you take it under advisement. What does taking it under advisement mean? You just leave them hanging.
Well, taking it under advisement can mean certain things. First of all, it can mean that the legal issues are complex enough that I haven't made up my mind, or I've had various arguments, or I got to research the law, or they ask me for findings of fact and conclusions of law, and I can't do that on the spot. No matter how many years I've been doing it. And sometimes there's a psychological aspect to it that emotions are raw. They've had a rough time in court, and I can let them cool down for a little bit before I send them what the final decision is and why the final decision was made the way it was. Sometimes with some cases, the emotions are so high, I know if I do and of course I have to do it in criminal cases. I usually have to do it in contempt cases. But the emotions run so high, if I do that, I got to get extra court security in. Because tempers go, people in the audience, go. So in other words, there's different factors to it. So there's legal, there's psychological. I would say the majority of the time is, well, I've heard good arguments, and I honestly don't know what I'm going to rule. So the better, you get a close side, it doesn't hurt to have me ruminate on it. Sometimes these people have been married for 22 years. Another 3 or 4 days isn't going to hurt. So getting it right, making certain I've understood everything, because sometimes people aren't the best communicators. So, and they use pronouns, and so it's not clear. And so to sort those things out is part of what my job is.
Well, I'm sure after you take something under advisement, you get lots of people following up. How long should someone wait before following up with you on if you've taken something under advisement?
It's
so
actually
that we're not harassing your staff.
No, it's actually driven by statute. It's based on the size of population in your county. And for Gwinnett County, we have a 90-day deadline. So it's 90 days. That decision's supposed to be made from the time of final argument. So let's say I've got a divorce case where they wanted to hear, they had the final hearing, but then they want a hearing, they want to reserve some issues on attorney's fees, say under 91514, or some other statute. They want me to reserve ruling on that. It goes to the time I heard my last argument on the case. But that's when the 90 days go.
Okay. That's
But
good
it's
to
a
know.
firm deadline, so.
And what's
If you haven't heard from me by day 80, I would appreciate the call because it might have got miscalendared.
well, I've heard that deadline before, but I've also been advised that if you ask a judge because they're late to give you an order, then they might give you an order you don't like. So,
I think that's nonsense.
No?
I mean, I could see the psychological aspect of it, but I don't know of anybody that blatantly makes wrong. And I've been doing this for decades. Quite frankly, I mean, as I told you, I carry anywhere from 800 or more cases at any given time. So if you just run the numbers, did one not get docketed? Because that's what we use. We use a docket. When does this 90 days run? I appreciate the second set of eyes.
Okay.
I'm not going to change my decision one way or the other. So,
all right. Well, that's good to know.
yeah.
Is there any financial advice you would give a newly single parent who's struggling to figure out how to make the household keep going on one income instead of two?
Oh gosh, folks, this goes back to partly what you talked about having a web and having a support system. You truly know you're a single parent where it's 2 o'clock in the morning, your child has just got sick all over the carpet, and you got to be at work at 6:30, and you can't afford to miss it. Single parents have a truly rough time, which is why the closer they are, provided that they get along with their family's not dysfunctional. Remember, we get those dynamics as well. I can't go to my sister or brother's house, they're high on meth. But having a functional network, because nobody can do it on their own, which is why, to some extent, some parents fail to see that really their best resource should be the other parent. It doesn't always work that way, but for those who do, who embrace that, which is why you try not to burn your bridges. Because again, nobody can raise a child solely on their own. Part of the thinking of various groups is to minimize the input of the other parent, and have that thinking, I can do it, and this other parent's just irrelevant. And you'll see that in some of your parent alienation cases. I grew up without a father. My child grew up without a father. It's not that important. That was your history. That's not necessarily the reality of the child. And various examples that go different ways.
So what happens to a child, like psychologically, when one parent talks bad about the other parent?
It is oftentimes, most often, devastating to the child on some level. Most children will feel an affinity towards each of their parents. There's rare exceptions that don't. A child always knows that they're the product of two parents, and if one parent is defective, what part of me is defective? And it also, the dynamics of a bond, and it oftentimes triggers guilt feelings with a child. It oftentimes, when parents fight like that, it can actually drive the child to the least safe parent. Isn't that ironic? Because the child knows they'll always be loved by the safe parent.
But
And
it's
that other
conditional
one,
with the
that
other
troublemaker that I think is going to dump me. So
Wow.
that's right. So all these things, that's why, in family law, we've got the law, we've got the code, but so many of it is based on sociological studies, psychological studies, in what do we have at this given time? And there oftentimes is multiple factors. It's not just, a simple black and white issue, which is why probably family law cases, those that bother most judges, are, the impact of our decisions. When we get self-represented litigants, we don't get all the facts. We know we can't make the best decision because you don't have the best evidence. And then the long impact on families. So it's a vitally important area of the law.
Well, what if during the divorce, the kids figure out that the divorce has happened and start asking questions? How does a parent talk to their kid about the divorce without, throwing the other parent under the bus?
Well, they clearly don't throw the other parent under you've got different stages as, you've got a 17-year-old going to be an 18-year-old next month. You've got your tweens, you've got your little children, you've got your preschool age, and the conversations need to be generic. And there's a lot of resources out there about talking to your child.
Any good
Really,
books that you can think of off the top of your head?
No, but
No, okay.
the library has a source.
Okay.
You can key it in on Amazon. Now, one of the best sites I think of and I always recommend it to my high conflict parents, or at least if one of them is the Co-Parent Dilemmas by
Yes.
Diane Dirks.
Yeah, she has a
and
good
Rick Voiles.
podcast.
And their site and their questions of how to talk to the child, what not to say. Then you've got your other quandary was, I'm not talking to the child, but the other parent is.
Exactly.
And, how do I deal with that? And they walk you through those things, but children and younger children tend to think of the world in terms of good and bad, which is why it's a hard topic for them. That's why they say children's movies quickly identify who's the villain and who's the good guy. There's not shades of gray for that group because they want that decision. And the long-term effects can be really harmful to the child's self-image, to how they engage with future relationships.
What are some of the most common reasons that people in Gwinnett County come back to modify their parenting plan?
Well, change of income. Oftentimes, I'll get high-earning men in the corporate world, and when men start getting laid off, unless they're currently with the federal government right now, which I guess, what was it, the chainsaw? Are you just part of the chainsaw?
I saw something. I saw a chainsaw. I don't know.
Yes, but
There's a photo up. I don't know what it was about.
high-earning men in their 50s is exactly when they tend to lose their job.
Really?
And get replaced by a younger MBA. So turnover of high-earning men in their 50s is a common phenomenon I see. So it can be change of income for either spouse. So change of income is a big driver. And, sometimes, life throws curveballs. Somebody all of a sudden has a was in a devastating car accident or other injury or has some health dilemma, or MS was under control for a number of years, and now I got to use a walker. Think of all the things that can go wrong. So health reasons, you get, changes in needs of the child. The child may want to go live with the other parent for a while. It's very common for teenage males between 14 and 16 to want to go live with their father.
I did it.
See, that's just, because again, males role model. And so they look for that modeling behavior. And it may be a parent and it may be someone else. And probably my saddest cases, and the ones truly difficult for me, are the relocation cases, or I've got two really good parents. And now all of a sudden another parent wants to move 1,000 miles away. It can be for good reasons, but it won't be a good outcome for the child. The child will never have the same quality bond when the parents live close together. I mean, I am looking for the least bad decision, not a good decision. And they're hard cases.
Well, Judge Davis, I really appreciate you spending so much time with me here today. I hope we didn't go over the amount of time that you could be here, but thank you so much for being with me today.
Well, appreciate the invitation. Appreciate you educating the bar and helping to educate those viewers who are not lawyers as well. Most appreciated.
Yeah. This has been the Dealing with Divorce podcast. See you next time.